Hello, and welcome to the League of Women Voters of Portland's Voter Forum for the candidates for election to the office of Position 38, 4th Circuit Court, which is Multnomah County. I am Chris Kobe, the moderator for this forum. The League is a nonpartisan organization dedicated to making democracy work. We believe democracy works best when voters are informed about issues and are engaged in their communities. We are presenting this forum to give eligible voters the opportunity to learn more about these candidates. We are grateful for the support from the Carol and Velma Sailing Foundation, the Weiss Foundation, the League of Women Voters of Portland Education Fund, and our media partner, Metro East Community Media. All 5 candidates for this position were invited to participate in this forum. 3 candidates appearing here accepted our invitation. We welcome these candidates, who are Jeffrey Oxier, Rachel Phillips, and Jennifer Myrick, and thank them for participating. The availability of this vacant office arose at the last minute, such that none of the candidates had the opportunity to put a statement in the Multnomah County voters pamphlet. However, information on all participating candidates may be found at vote411.org, which is the League of Women Voters online candidate and ballot measure website. Under the voter forum protocol agreed to in writing by the candidates for this event, each of the speakers will give a 1-minute opening statement, followed by questions we have prepared based upon league positions and league members' interest. Each candidate will be allowed a 1-minute closing. Each speaker will have up to 1 minute to answer the question. The initial order of speakers here has been determined by the Oregon Secretary of State's random alphabet for this election and previous elections. So the candidate giving the first opening statement will give the first closing statement. Mr. Oxier will give the first opening statement. Mr. Oxier, please proceed. You may need to unmute yourself.
Thank you. My name is Jeff Oxier, and I hope to be Multnomah County's next circuit court judge. Over 20 years ago, I worked in a domestic violence shelter, and it inspired me to go to law school to prosecute domestic violence cases. And now, 20 years later, I'm supervising the domestic violence unit in the Multnomah County DA's office. One of the reasons why I'm running for judge is because I believe someone with my level of experience working with survivors of abuse will help make the courthouse fairer overall. And that comes after lots of years of experience, including enough time in this office to know that oftentimes the people that are accused of crime are survivors of abuse as well. I'm proud to have the experience and the support of over 25 Supreme Court, Circuit Court, and senior judges in the state of Oregon. And I'm excited to tackle the backlog of criminal cases that have existed in Oregon since COVID.
Ms. Phillips, you may give an opening statement.
Thank you. My name is Rachel Phillips, and I am running for this position because I am the only candidate that has extensive experience representing victims of crime as well as individuals accused of committing crimes. I want to help everyone, especially crime victims, navigate the system in such a way with dignity and that they feel heard and listened to. Furthermore, with the unrepresented crisis, there are over 5,000 unrepresented individuals accused of crime across Oregon right now, and that delay is terrible for crime victims. The status quo isn't working. It's just not. And we need someone in the position who understands the perspective of crime victims and how the delay impacts them and how the delay is bad for defendants as well. We need someone who's I am someone who can bring that experience, follow the Constitution, and be an effective judge in Multnomah County. Thank you.
Ms. Myrick, you may give your opening statement.
Thank you. My name is Jennifer Myrick. I'm running for Multnomah County Judge. I am one of the only candidates that has experience on both sides of the aisle within prosecution as well as defense work. I too have worked with crime victims, and I also have worked with local community agencies. I'm very passionate about houselessness, drug addiction, and mental health issues. Further, I believe that I have the solutions that we need for a cultural shift that would not only attract new public defenders to the career, but also keep those that are in here by respecting, listening, and being grateful for the providers that we have.
Right. Our first question goes to Ms. Phillips. How, if at all, do you expect the role of a Multnomah County trial court judge to change in the next 6 years?
I think a lot's going to depend on how we come out of this crisis if we do. At this point, with over 5,000 individuals without representation, it's the highest it's been in the past 5 years. I also think developments in technology are going to impact the way we conduct cases. The pandemic opened up different avenues, allowed for more remote appearances, and the way our society is changing. Hopefully, the position of judge is able to make justice and the court system much more accessible to everyone, and to continue to follow the rule of law and the Constitution so that it is fair to everyone as well.
Mr. Oxier, your answer?
I'm hopeful that 6 years from now, we'll see cases get resolved a lot more quickly than they currently are getting resolved. Since the pandemic, there have been understandable delays, and I'm excited to implement new policies that will hopefully make it so that criminal cases and civil cases get processed at a quicker rate. Some of the things that I think we could do is sort of relax some of those pandemic social distancing rules. Currently, there's a lot of waivers of appearance that allow the accused to appear by phone. And sometimes that makes a lot of sense, but we need to get all of the parties, defense attorneys, prosecutors, victims, defendants, in the same room so we can resolve cases expeditiously.
Ms. Myrick, your response?
Yes, thank you. So in the next 6 years, I see the opportunity for us to change the culture of the courthouse. Often what we see is individuals on the worst day of their lives. I want the courthouse to be a welcoming place, a place where individuals aren't scared to speak. They aren't scared to appear for their court appearances, as well as be a soft shoulder and a gentle access to help, which people often need when they are in that court system. Further, I think that we need to protect the health of our providers. I think that the mechanisms that have been put in place actually protect individuals, and COVID is still very real. It is a danger to our providers. It's a danger to public defense attorneys, who are the ones that are going to the jails and interacting with the public. Our public defenders are at risk, and we need to take greater precautions for their safety.
Our next question goes to Mr. Oxier. How would you work to enhance public understanding of the circuit court's role in our communities?
One way I would do that is by really committing to explaining my reasoning and the reasons why certain outcomes are happening in a way that is respectful of that centers the defendant's role in the courtroom as well as the victim's role in the courtroom, so they feel heard and they understand why outcomes are happening. And also getting out in the community and explaining what the work is that we do, participating in community groups, looking for opportunities to get off the beaten path. I'm not just talking about going to bar association functions, getting out there and to communities that aren't used to seeing lawyers and judges appear and talk to them.
Ms. Phillips, your response?
Thank you. I think Mr. Oxier makes really good points. I think more outreach is needed. We certainly need to encourage more participation from our community and to emphasize the importance of jury duty, to emphasize the understanding of the process, even when it can be overwhelming, and more outreach so that we ensure more participation and that it is accessible to everyone in our community.
Ms. Myrick, your response?
Yes, so access to justice is a central tenet of my campaign, as well as just who I am as an individual. As a public defense provider, I have done presentations for organizations such as Don't Shoot Portland or Legal Aid. And I really want to share that knowledge. That knowledge interests the public. The public wants to know these things. They want to be empowered with that information. Therefore, I think if we really branch out, and the Classroom Law Project is a great example of starting folks young to be educated in the legal sphere. But I think what we need is a bit more to let them know that we are not to be feared.
You are watching the video of the voter forum of the League of Women Voters of Portland, or listening to our podcast for candidates for the position of judge for position 38 of the Fourth Circuit, which is Multnomah County. The next question goes to Ms. Myrick. What do you see as the role of the Multnomah Circuit Court to address the behavioral health crisis?
Yes, so the Multnomah County Circuit Court is unfortunately become the access point for mental health services. We have a systemic pattern of cutting mental health services and funding throughout our state, and it's actually even been a national pattern. And what we're seeing is individuals that are at the end of their rope, and unfortunately they're being brought in on low-level misdemeanors often. But what we can do is we can be a hub for those services. I know that Multnomah County has amazing programs in place. They have the McJerk program. They also have social workers in the courtroom. I want to see a greater enhancement of those services presence in the courtrooms for individuals to utilize.
Mr. Oxier, your response?
Thank you. I agree with a lot of what Ms. Myrick says. The criminal justice system is a really blunt tool to address what is not really always or very rarely a criminal problem. It's a public health problem. And sometimes, unfortunately, it is the safety net and the way that we get people who are suffering the services they need. One of the things that I would be passionate about a judge is, I would be passionate about as judge is providing more pretrial services so that people who are suffering from mental crises can get the help that they need out in the community, more robust support for these people so that they can live safely in the community, get services they need, and then we can decide if we need to even continue the criminal prosecution at all at a later time.
Ms. Phillips, your response?
To add on to what everyone else has said, I think one of the problems is the court is somewhat limited in its capacity. And one of the issues that we are having in Multnomah County is we simply don't have enough programs and enough service providers. And one way that the court can address that is perhaps loosening some of the barriers for entry into mental health court. Mental health court is a great program, but sometimes individuals are denied entry just based on some of the restrictions. And so opening that up is a way of working towards more community safety, since right now we simply do not have enough mental health providers in the community. That's one way that the court could take to address those issues.
All right, the next question goes to Ms. Phillips. What effect, if any, might the philosophy of restorative justice play in your performance as a judge? Restorative
justice is a wonderful thing. And we need more teachings on it. We need more education. I see it firsthand, especially as my practice has transferred much more to victim representation in the past several years. And restorative justice gives victims an opportunity to be fuller participants, especially if they have legal representation through the process. District attorneys aren't allowed to actually represent victims, as I know Mr. Oxier knows. They represent the state, right? And in Oregon, we have a statute that allows victims to have representation, and allowing them to participate in the process is a way to help them get healing and get closure. And it's a really important part of our justice system.
Mr. Oxier, your response?
One of the reasons why I'm excited about being a judge is so that I can participate in judicial settlement conferences. I think I'm someone that is trusted by the defense bar as well as the prosecution to help make a case resolve in a way that's favorable to both sides and resolve efficiently so public defenders can move on to the next case and we can efficiently resolve cases. A lot of the principles of settlement conferences has to do with restorative justice work. The more a victim feels heard during the course of a negotiation, the more they feel like they're seen as someone who survived abuse, the easier it is for both sides to reach compromise. And I can say that as someone who has worked on cases involving victims for well over a decade.
Ms. Myrick, your response?
Yes, I do believe that we are all on the same page regarding this, and that we want to have that collaboration amongst the parties. Defendants don't have the opportunity to speak to the prosecution, as that is prohibited by ethical laws. But defense attorneys certainly can speak to victims when they want to, and so can the defendants can speak to the defense. So we're kind of the epicenter of the communication. And I think that that's what makes defense attorneys so extremely well equipped to become a judge. We have the tools in our toolboxes and we know how to use them. Giving the empowerment to the victim to be heard and craft that resolution is something that will help everyone.
Our next question goes to Ms. Myrick. What, if any, weight should voters give the number of a judicial candidate's financial supporters, the identities of their donors, and the amount of their average contributions?
Absolutely. So in a judicial race, we are ethically prohibited from asking for money. This is a rule because we want a judge to not be beholden to donors or special interest, endorsements, and the list of contributions can often show a system of patronage. It can show a bias, it can show a coalition, and it can also show the exclusion of others. That's why at my campaign, we will not be asking for money. If individuals do donate, they will do so without request, and we will use that money. And then if there's anything left over, a surplus, we will be donating it.
Mr. Oxier, your response?
Since this campaign began, I've been really flattered by the number of people who have reached out and expressed willingness to support me. As I mentioned, that includes judges, that includes Eliza Kaplan, the co-founder of Oregon Innocence Project, and certainly people with a prosecutorial or victim rights background as well. And in those conversations, one common refrain I hear from these judges and other folks endorsing me is they cannot believe that there's no voters pamphlet statement in this race. And we have to get the word out about who we are. And this is America, and Ms. Myrick is absolutely right. You cannot solicit donations, but we need to get the resources to communicate to the public who we are.
Ms. Phillips, your response?
Thank you. Because this is such a quick race, I will say that certainly Mr. Oxier had the advantage as he already had a campaign finance committee because he's run for elected office before. He ran for the elected office of Columbia County District Attorney. I will say, though, in that position, he was in the best position to close cases quickly. And Columbia County, when he was there, is the slowest county for resolving cases. So endorsements, I think, especially in such a short-term race, are a reflection of the status quo. And again, as a candidate, I think I am not the status quo at all. And so I think voters can take them for what they are, but the status quo has led us to 5,000 unrepresented defendants. It's time for a change.
The next question starts with Ms. Myrick. What actions might you take as a judge to further public respect for the courts and the rule of law?
Absolutely. So one of the judges that I've had the opportunity to appear in for a number of years, who is now retired, Judge Ted Grove, really impressed me and taught me the importance of listening. Often when you listen to an individual and you're not there to talk down to them and you're not there to talk at them, you're able to really grasp what issues perhaps that haven't been noticed and might actually be the cause of why you're there. So listening to individuals and giving them their day in court is the greatest gift that we can give the public of the Multnomah.
Phillips, your response?
Thank you. I would say independence, knowledge of the law, and the courage to follow it. The judge that I respect and look up to the most and would emulate would be U.S. District Court Judge Michael McShane. He is the individual that made the ruling on the Betchart opinion, which is the opinion that said that Oregon cannot hold people in custody longer than 7 to 10 days if they do not have legal counsel. And he had said that in fact, I believe he had said it was an embarrassment that it was occurring and that literally we have suspended the Constitution when it comes to this group of individuals. And I think following the Constitution and the courage to follow the Constitution is very important in a judge.
Mr. Aksher, your response?
Yes, I'm going to mention two judges too. One judge I want to mention is Ben Swade in Multnomah County. I was prosecuting a murder case in front of Judge Swade. What kind of blew my mind, and I've never seen from a judge before, was how he would take the bench, and before the record went on and things got formal, he would look the accused, this is a person accused of murder, dead in the eye, and have a very polite and respectful conversation. It's like Judge Swade didn't even notice the lawyers in the room, and they were just, it was a meeting of minds between two people, one of which probably did not expect the judge to talk to him that way. And I'm genuinely excited to emulate that if I'm lucky enough to be a judge. The other judge I wanted to mention was U.S. District Court Adrienne Nelson, who was in Multnomah County for the first 10 years I practiced here, or for a portion of it. She had such a safe space in her courtroom for young lawyers, such as myself, to make mistakes and be forgiven for those mistakes. And she was a mentor to me, and I'm really proud to know her and consider her a friend.
Next question goes to Ms. Phillips. To what extent should a judge be a model of integrity, and why?
Judges absolutely have to be a model of integrity because they have to preserve neutrality, and they have to be aware of their biases so that they can avoid them while they are on the bench. I think it's absolutely imperative that judges be that model. And I've had a number of friends from law school who have gone on to the bench. I've had attorneys I admire gone on to the bench, and they have to sort of reduce their friendships a little bit so that there is zero appearance of bias towards the lawyers that appear in front of them. And I greatly respect that. And I think it's important for all judges.
Ms. Myrick, your response?
Yes, thank you. So the judge has to be a model of integrity. We need to have the public trust in the judiciary. We cannot have someone that shows favoritism to either side of the aisle. As someone, again, with experience prosecuting and defending cases, I believe that I have that moderate view. I have the opportunity to work in Portland, pay myself through school here in Multnomah, and I have the humanity to understand that there is no one that's superior and that we are all in this together and we all want the same thing in the end, which is peace.
Mr. Oxshire, your response?
I think temperament is very important, really making sure that everyone leaves the courtroom feeling like they were heard no matter what the outcome is. And I agree. Judge Ramrus had told me when he was taking the bench after a career as a prosecutor, he said, gosh, I'm not going to be able to go to lunch with the people I used to go to lunch with, but appearances matter. And of course, you're allowed to be a human being and socialize outside of the courtroom, but you've got to constantly remember that there are litigants who might be watching you that don't fully understand your ability to separate your friendships from your rulings, and appearances matter.
All right. The next question goes to Mr. Oxshire. What in your life experience and professional skills qualifies you best to serve as a judge?
I would speak directly to my experience working with survivors of domestic violence over for nearly 20 years. And I'll give you an example just by way of illustration. I've done this work long enough to realize that there's not always a good side and a bad side. And I've realized that the system can make mistakes. One thing I've been working on over the last year is I've worked to build a survivor-centered diversion program in the Multnomah County DA's office. What I realized was that African-American women in Multnomah County, they comprise 5.3% of our population, but yet 30% of the women who are arrested for domestic violence are African-American women. And when you look beyond the police report, you realize a lot of those women are actually the survivors of abuse. Those sorts of learning experiences, understanding that things aren't always black and white, and working with people from all different backgrounds, I think will make me a good judge.
Ms. Phillips, your response?
Thank you. I've never been a part of the system. I grew up in very modest circumstances. I had to work to get through school, undergrad and law school. And I went to law school at the age of 36 after personally experiencing a horrible experience through the way the system treats people in a civil case. And I think that, and it puts me in a unique position to really understand what it's like for people thrust into the criminal justice system who have never been in it before, and how overwhelming that can be, and to be that person who understands and hears them and sees them.
Ms. Myrick, your response?
Yes. So again, as a defense attorney, we are tasked with not only representing an individual, we are the ones with actual clients, but we are also tasked with being this point of access for social services. Therefore, when we talk about engaging in treatment, if we talk about finding housing, or if we're talking about mental health services, it's going to be tasked with the defense attorney, especially the public defender. Therefore, we have the toolbox and we are tasked with finding those solutions for our clients. That is the greatest asset that we can offer as a judge. Now, my personal life and growing up, I was raised by a single mother. We did struggle to make ends meet, and I did again put myself through school. I've worked so many jobs. I've been a bartender, a barista, a florist. And I'm proud of that. I'm proud that I can walk down the street and see people that I've known my entire life. And I'm proud that I can have an office 6 blocks away from the house where I grew up and see those people in my community.
The next question goes to Mr. Oxhier. Does an attorney with prosecutorial experience or with criminal defense experience make a better judge, and why?
A prosecutor does not make a better judge than a defense attorney, and a defense attorney doesn't make a better judge than a prosecutor. I think we can all agree on that. And because, gosh, there are just so many examples of judges with defense attorney backgrounds that prosecutors love to appear in front of, and judges with prosecutor backgrounds that prosecutors would prefer to avoid. It really comes down to temperament. And I think after you've practiced law long enough, you really, you get humbled enough to understand that all the pieces matter.
Ms. Myrick, your response?
Yes, as previously stated, the defense attorneys are tasked with connecting our clients to the services that we need. We are the ones that are going to each specialty court and assessing which one is best for our client, what services would best suit their needs. Every day we talk to an individual in mental health crisis. Every day we talk to drug-affected individuals. We know the signs and the patterns, and we can recognize them because we're the ones working directly with them. Further, I regularly talk to victims who feel unheard, and I make sure that their voice is present in the courtroom. Therefore, I do believe that defense attorneys are the better option.
Ms. Phillips, your response?
I agree with Mr. Oxier. I don't think it matters. I think it's the individuals who are the most in touch with their humanity. I'll name 4 judges I admire, and 2 are former defense attorneys and 2 are former prosecutors. Judge Michael McShane, who started at Metropolitan Public Defender, where I started and worked for 8 years. Judge Amy Baggio, whose position that we're running to take, that she vacated because of her federal appointment. She started as a defense attorney. Judge Eric Bergstrom, who started in the Multnomah County DA's office, and Judge Jean Kerr-Mauer, who also was a Multnomah County district attorney before she became a judge. And all 4 of those judges, incredible settlement judges for judicial settlement conferences, and incredible examples to follow for anyone who takes on the bench.
Next question goes to Ms. Phillips. Do you have a preference in assignment within the court if elected? And if so, what would it be and why?
I would go wherever assigned, but I would probably have a preference for settlement conference rotation, especially with Measure 11 cases. In my experience as a defense attorney, I have worked on everything from misdemeanors to murder cases. And it takes a certain skill set to help settle cases, to speak to the prosecution, to speak to the defense, to speak to the victim and the victim's family, and to get everyone to come together to some sort of a resolution. And the 4 judges I previously named are incredible at working those kinds of settlement conferences, and that would be a good way to resolve cases to help reduce us from our 5,000 unrepresented, to free up the closed cases and allow defense attorneys to take on more cases and to help resolve this crisis.
Mr. Oxhier, your response?
This is the position we're all vying for is a general bench position, which means on any given day you might be assigned to supervise a treatment court, oversee a murder trial, or do a series of misdemeanor trials, maybe take on a child support case, do a settlement conference. I'm like Ms. Phillips. I am really excited to do settlement conferences. I think my relationships with the DA's office will help get to efficient resolutions that are maybe even more favorable to the defendants as a result. But every litigant matters. One thing you've got to remember when you have this job is it's one of the biggest days in the lives of whoever is appearing before you when they're a person who's not a lawyer and they're appearing in court. And I think really treating every case as such is important.
Ms. Myrick, your response.
Yes, so I would say that my preference for assignment does mirror those of Ms. Phillips as well as Mr. Auxier. I am extremely passionate about, obviously, the criminal justice system. Settlement is a vital asset, and that is necessary in order to reach resolution and work through the backlog of cases. Further, again, as stated, I am extremely focused on providing social services and mental health, as well as addiction services. So the treatment courts and the mental health dockets are something that I would consider an absolute privilege to be a part of.
All right. The next question goes to Ms. Myrick. What, if any, changes in the Oregon jury system do you think should be considered?
Yes, so, I once had a trial where the prosecutor, repeatedly tried to strike people of color off of the jury. And I had to challenge that under a state case called Batson. And I think that what we need to do is have greater pressure on the prosecution to not use those strikes to remove people of color from juries, especially when there's a person of color as a defendant being prosecuted. Also, within the jury system, I am constantly impressed. Our juries are smart, and we need to trust them to oversee the matters and arrive at those correct conclusions. And I respect those decisions.
Mr. Auxier, your response?
One thing I'm excited about is increasing the pay that we give jurors. Jurors do get a small check when they serve, but it should be bigger because right now people who are struggling paycheck to paycheck cannot serve on juries. They need to go back and work in order to make ends meet at home. We need to find a way to have people like that be represented. Also, the Multnomah County DA's office currently is experimenting with banning peremptory challenges in misdemeanor cases. And I think that's exciting because I agree that racial bias and other biases can creep in when we're deciding which jurors should be removed from a case. And I'm excited to see how that experiment turns out.
Ms. Phillips, your response?
I would echo Mr. Auxier's statement about higher pay for jurors, and I think that also goes to accessibility. I think the court system, especially for more of the underserved communities, is not seen as a welcoming environment, and I think we need to, better pay for jurors and more education so we continue to get more diverse juries, so that when we say someone is having a jury trial with a jury of their peers, it's actually accurate, and it is a jury of their peers.
Next question goes to Mr. Auxier. What, if any, criminal sentencing reforms would you support?
One that comes to mind is giving judges more authority to revisit their sentencing decisions. And because sometimes at the time of sentencing, a long prison sentence seems appropriate, but with the passing of time, you realize that that's no longer necessary and in the interest of public safety. I was one of the few district attorneys in Oregon to support publicly and testify at the legislature in favor of Senate Bill 819, which gave prosecutors more authority to undo wrongful convictions. I'm really excited. I would support judges having that authority as well. Of course, that's up to the legislature, but I think that could be a helpful thing.
Ms. Phillips, your response?
I think Mr. Auxier is right. We have to follow the law, and any changes would be, the scope of the legislature. In the past, I have absolutely supported measures. For example, I publicly supported reform to Juvenile Measure 11, the changes that were done so that now they cannot automatically be charged. It has to be more steps taken to charge a minor with a Measure 11 offense. I think that's a really great safeguard. I think revisiting Measure 11, I have advocated in the past. Obviously, once you're a judge, you can't advocate, but certainly my past advocacy in front of the legislature has been for Measure 11 reform. And hopefully the legislature will revisit it. Until then, as a judge, we all would be expected to follow the law as it is.
Ms. Myrick, your response.
Yes, so I really want to have a frank and honest discussion about Measure 11 and how it plays out in our day-to-day in the criminal justice system. Often, what it is used as is a way for the state to unfairly, in my opinion, pressure someone into a deal. Even if you have a strong case as a defendant, the opportunity for you to be convicted by a jury and have a mandatory 10-year sentence per se and not eligible for programs often is the case. It is just a tool used to pressure people. And what you end up doing is you end up taking a deal when you could have proved your innocence, but you can't gamble 10 years of your life. We need to make it so that it's equitable and fair for individuals that are coming into the criminal justice system to resolve their cases without those threats.
The next question goes to Ms. Myrick. Please share your thoughts on the appropriate role of the use of video in court proceedings, including jury trials. When should personal presence still be required?
Yes, so perhaps my greatest fear is this 1984-esque notion of jurors appearing via video and not being able to fully engage and appreciate the humanity of the witnesses, the defendants, and the victims. When you are in a courtroom, you're able to look at an individual, observe their behaviors, observe their facts and characteristics, and able to make a more accurate determination. While I do advocate for video appearances for health reasons for individuals to protect the safety of the attorneys and those in the courtroom, I do want to protect the trial procedure and not offer the opportunity for individuals to appear via video in that circumstance.
Mr. Oxier, your response?
Yeah, to piggyback on what Ms. Myrick said, I think it's really important to have everyone physically present in the same room together. And Ms. Phillips will remember that one of the older court procedures that no longer is in effect was a system called drug call, where all of the property crime lawyers, the prosecutors on one side, the defense attorneys on the other, were forced by the judges. It was part of the procedure to all sit in a jury room together and discuss our cases and then go out to the judge and report what kind of progress we made, either progress towards scheduling a trial or progress towards a plea deal. I understand why, because of the pandemic, we just moved away from that. But gosh, those were some of the greatest moments. They were funny moments sometimes, like we all laughed together. I just think it increased our collegiality, and it definitely increased the efficient resolution of cases. That doesn't happen when people are on Zoom.
Ms. Phillips, your response.
Mr. Oxier is right. When you have everybody together like that, it led to the quicker resolution of cases. Quite frankly, because everyone was forced to be in a room together and talk. And you can zone out with video and technology. And I think the in-person is really, really important. It definitely makes a difference. And of course, I absolutely think that getting everybody in the same room, especially for jury trials, I mean, a defendant has the right to confront their accuser, and everyone actually being physically present it's important. And actually, since the pandemic too, it used to be that you, again, in the old courthouse, you could walk around from like a drug call with a prosecutor and find a judge who was available and say, hey, can you help us hammer out the terms of this? We're close, we can't get there. and it led to a quicker resolution of cases.
Mhm. Very good. The next question goes to Ms. Myrick. How would you handle a situation where your personal beliefs conflict with established law or legal precedent?
Right. So your job is to follow the law. As I stated before, I have my personal reservations about Measure 11 and my personal conflicts about it. However, if a individual is convicted of a Measure 11 crime in trial, I will impose that minimum sentence and I will follow the statutes and laws accordingly. There are often times when I see a court case where, say, the defendant is truly a victim and I'm simply trying to provide that truth. And I think that in those matters, my personal beliefs align with the truth, and providing that truth is probably the greatest gift that I can give to not only my client, but also the courtroom and the judge. So as a judge, I seek the truth.
Ms. Phillips, your response?
The Constitution is supposed to protect everyone. Due process is important for everyone, and it's, we don't apply it just to people we like, right? And we don't suspend it for people we may not like. And again, so due process is key here. Following the Constitution is key, and it's really important for judges to be impartial and neutral and put aside any personal feelings and follow the law. And I would go back to Judge McShane. I think Judge McShane in the Betchart decision, he was courageous. He followed the law. He followed the Constitution, and that's what a judge should do.
Mr. Oxier, your response?
You absolutely take an oath to follow the law, but by the same token, I think when something feels wrong in your gut, you should ask yourself, am I ruling a certain way because that's what all the other judges do? Or does the law really require me to do that? I'm someone who has been a prosecutor for almost 20 years, and I've certainly been guilty of approaching cases in a conventional way, seeking the sentences that my boss told me to seek, and not really thinking critically about what was the most just thing. I'm guilty of that. I think I do that a lot less now than I did 10, 12 years ago. And I think judges need to challenge themselves, to ask themselves, am I just doing this because that's what we're supposed to do? Or that's what everyone else does? Does the law really require me to do something that feels wrong? Constantly checking yourself that way is good, but ultimately I agree, you have to follow the law.
The next question goes to Ms. Phillips. Please explain your understanding and belief of the role of punitive damages in civil litigation.
In terms of the punitive damages in civil litigation, I would go with what was presented and the experts and apply it in the best way possible.
Okay. All right. Ms. Myrick?
Yes, so punitive damages are something that's allowed by statute, and punitive damages are often allocated in matters where there's claims of bad faith, there's claims of gross negligence, there's claims of great harm caused to an individual. Punitive damages are widely used in cases where a plaintiff has suffered personal injury and they are suing, say, a large corporation or business. And while you may sue, like in a property dispute, for $1,000 against your neighbor, in other matters, there are individuals suing for millions of dollars. And in those matters, punitive damages need to show that there is indeed retribution, that there is justice, and that that money that's taken from that corporation or business is going to be a just result and punishment for their actions.
Mr. Oxier, your response?
Their standard civil damages are intended to make the plaintiff to put them back in the place they were originally before the harm occurred. And punitive damages have an intent to right a wrong on a more policy-based level. And that's something that I think can be a very valuable tool and could help a corporation realize that they don't just need to pay off this one plaintiff, they need to change their entire approach to a certain way of doing business. And I think that can be really good.
You are watching the video of the voter forum of the League of Women Voters of Portland, or listening to our podcast for candidates for the position of judge for position 38 of the Fourth Circuit, which is Multnomah County. The next question goes to Mr. Auxier. As far as you are concerned, to what extent should a judge consider the financial status of a criminal defendant in setting bond?
Bail amounts that are set by a judge are supposed to be intended to ensure they appear in court the next time they have a court date. There should be enough skin in the game that they're motivated to come to court, because that way they won't lose the money that they posted bail for. Now, the whole money bail system, it's a little weird, right? I think of some of the prosecutions that have happened in Multnomah County in past years where, for example, there was a Saudi national who was infinitely wealthy. He killed someone on Hawthorne Boulevard and then drove away from the scene, if I remember correctly. He was able to post bail and flee the country, and the grieving family of the young girl who was struck on Hawthorne Boulevard never got to see justice. You shouldn't be able to get out of jail because of how rich you are. That's one of the reasons why I'm very skeptical of money bail to begin with.
Ms. Myrick, your response?
Yes, so the case of Amber, who was murdered on Hawthorne Boulevard, is an excellent example of how the bail system has failed us. Going back decades, we have a case, State v. Sutherland, that holds that a judge is to consider the defendant's ability to pay when setting bail. Often there will be a bail schedule, but we are driven to look beyond that. We are driven to look at, as Mr. Auxier said, what will guarantee that this individual comes back for their court appearance so that justice can occur. And no one should be exempt from being held accountable because of their bank account.
Ms. Phillips, your response?
When it comes to bail, I think one of the problems with cash bail, money bail, is that we have two systems of justice, and that individuals who can afford it can easily bail out, and then individuals of modest means cannot. And so in the bail setting and in the release decisions for the court, there's absolutely, of course, defense attorneys can raise extreme hardship, undue hardship, in an attempt to get the bail lowered. But then that means that individuals of modest means are already, they're starting out several steps behind because of that. And so, judges need to take into account ties to the community, prior criminal history. Will they show up to court? Because that's really, and the public safety component as well. And that's really, those are the main components that need to be considered. And so bail plays a part, but really it shouldn't play as heavy a part as it has in the past. We really need to be treating everybody in terms of community safety and will they come to court. That's the main reason for bail, is to ensure an appearance.
Thank you. The candidates may now provide their closing statements, with Mr. Auxier going first.
When on the day that we all filed for this election, and I realized, wow, I'm in a race with four very formidable and serious and qualified opponents. And then I started getting messages from people I wasn't expecting to get messages from. People like sitting judges, Supreme Court justices, defense attorneys, and of course, fellow prosecutors. Nate Vasquez, the DA-elect, and Mike Schmidt, the current DA, are both endorsing me. I'm really proud to have that support, and I would like voters to consider that I have people who believe in me and believe in my sense of justice from very diverse backgrounds. I'm also, as I mentioned before, really excited to take my background working on domestic violence cases to the bench. I think that's a perspective that will make the courthouse better overall. And most importantly, I love this courthouse. I love Multnomah County. When I was the Columbia County DA, you can ask any of my coworkers, I was nostalgic for the 9.5 years I spent trying cases in Multnomah. There's an energy here that's special. There's a collegiality too, and I hope to have your vote.
Thank you. Ms. Phillips, your closing statement.
Thank you. As someone who was not involved with the court system at all and didn't attend law school until the age of 36, I'm the only candidate that brings a lived life before court and not knowing what court is like, and a certain amount of empathy and humanity to the court system. Moreover, I am someone who has also channeled my anger very effectively into making things better for people. This is a little nerdy, but in my trial experience, and losses, I have ultimately gone on to have 14 wins at the Court of Appeal, where I lost the trial, but properly preserved the legal issues. So the appellate attorney could then argue it to the Court of Appeals and get the case reversed. And that's happened in murder cases as well, where I properly preserved those issues. So I have an understanding of the law and an understanding of lived experience outside of the court system, just as a normal person. And I am really concentrated, as well as having represented individuals accused of murder and crime victims of family members who have lost a family member to murder. And I bring that experience, and I think that makes an effective judge from having viewed all of those sides and understanding it.
Okay.
Thank you.
Closing statement, Ms. Myrick.
Yeah, so I too have lived a life prior to becoming an attorney. And like I said before, I am a part of this community. I've been a part of this community for a very long time. Individuals know me in the community beyond being an attorney. And what I do is I bring the opportunities for those individuals to be empowered within the legal system, as well as that soft shoulder and welcoming to the legal system, so that individuals are not scared. I believe that the court should be gentle with a lot of the individuals that come through. Furthermore, I have experience as both the prosecution and the defense attorney. I have the tools in the toolbox to further assist the people of Multnomah. We are in a time where we need to heal, and I want to be that healing force in Portland. We need someone that has this experience of financial insecurity, of housing insecurity, food insecurity, and that has been able to climb through. I bring that, and I want to share that with the people at Multnomah so that they feel seen and heard at the Multnomah County Courthouse.
Thank you. This concludes today's voter forum with 3 of the candidates for the position of judge for position 38 of the 4th Circuit, Multnomah County. We thank all 3 of the candidates for their participation. Please share this forum recording and podcast with your family and friends. We all need to be informed voters. If you are registered by October 15th, you should receive your ballot by October 22. As with all Oregon elections, almost all voters will participate by mailing their ballots only, although in-person voting is available. Check your Multnomah County voters pamphlet online or when the copy arrives by mail at your household. To be counted, ballots must be postmarked by Tuesday, November 5 at 8 p.m. You can also find an official ballot drop box location near you by checking with 411.org, or the Multnomah County Voters Pamphlet. The League of Women Voters is a nonprofit membership organization. We hope this forum was meaningful. We welcome you to join or contribute at lwvpdx.org. This is Chris Kobe for the League of Women Voters of Portland. Thank you for watching and listening and for being an informed voter. And remember, your vote counts.